Friends, it is Joey Hood in the house here. Judd A., Chairman. Good morning, sir. How are you?
Good morning, Paul. Thank you for having me on.
It's a pleasure. Look, I thank you for coming in. We've covered a lot of bills for a lot of times, and sometimes we just do not understand. All of us rank and file out there, us lowly people that just all we do is vote, and we don't understand these things. And this one has got to be on the top of the heap for me not understanding why we couldn't get a bill out to protect our daughters and mothers and aunts, et cetera, et cetera. And I'm going to let you have a little leeway here to tell me exactly why and this, some other things about this one. But first of all, your thoughts on this one.
Thank you, Paul.
Yep.
I want to start out with a couple of sayings. You never judge someone's character based on the words of another. And the old saying goes that the dog that has the loudest bark usually has something to be afraid of. I want to let the people of District 35 know, I want to let the people of the great state of Mississippi know that the House signed conference reports on the SAFER Act and the Bill of Rights for Women. And as the bill works itself through the process, there's...
Wait a minute, whoa. The bill died. What do you mean you signed it?
We sent conference reports over to the Senate for them to sign, and the Senate refused to sign the SAFER Act that the House sent over, and they refused to sign the Women's Bill of Rights.
Are you saying that you got the bill out of committee on time and you did not let it die in your conference committee?
I did not let it die in the conference committee. There was an original SAFER Act that did not make it out of committee. We did pass the Women's Bill of Rights.
Are we talking about Josh Harkin's bill, first of all?
Yes, Josh Harkins. There was a Women's Bill of Rights that came out of Judd A. We passed it. The Senate passed the SAFER Act.
But did you let that out of conference?
Give me just a second to explain, Paul. The SAFER Act came over from the Senate, and then we inserted the Parents' Bill of Rights in it with a reverse repealer. And so the Women's Bill of Rights and the SAFER Act both went to conference.
According to your colleagues you waited till the last minute as far as to pick up on it was sitting there for 2 weeks as far as the Senate bill.
Well,
you waited for the last second to do this.
Well, Paul,
and yes?
There was only two people that are privy to the conversations with regard to the SAFER Act and the Women's Bill of Rights. And I am determined to pass a SAFER Act that has some teeth in it.
What did you want in there? Let me say this. I tried to read over this thing last night because I called numerous people. I got numerous information, and I'll go through some of this because what it seems like to me on the outside is that you were holding out to ingratiate trial lawyers.
Well, Paul, let me go through.
Wait a minute. Would you categorically say that nobody's going to be better on this one but trial lawyers had your bill? Had they acquiesced to your demands on this?
Paul, I want to go back to the original bill that was introduced in the SAFE Act because I think you need to let me explain or let me try to explain how the bill got to the point to where it was at. The original bill that was introduced by Senator Harkins actually applied to all public buildings, counties, municipalities, and state agencies. It also applied to restroom facilities, required these entities to have 90 days to get rules and regulations, had a criminal trespass offense as well, and in that original bill, it had compensatory damages, injunctive relief, declaratory relief, punitive damages, and attorney's fees.
Okay, wait a minute. What part of this did you disagree with?
I don't disagree with that part right there. What I disagree with is as we worked this bill through the process, it went through the Senate and they amended it in committee. And when it came out of committee, they removed the trespass, they removed the damages, and basically only applied it to...
You're talking the Senate here, Joey?
Yes, sir. Yes, sir.
Okay.
And they only applied it to colleges and universities and IHL, not public schools. So when the bill came over to the House, we brought it out with committee, put a reverse repealer in it, and also added the Parents' Bill of Rights to it. There's an issue going on in this state, Paul, with regard that parents can't get their records of their children if they're over the age of 14. So we passed that bill out of the House, and I wanted to keep that alive because I think it's very essential that parents be able to receive their medical records of their children. There's a company out there called MyChart that's not allowing parents to get their medical records if their children are over the age of 14. And I think that's imperative, Paul, that we do that.
Why was this in this bill?
Well, we added it to try to keep it alive like we do on other things.
Mm-hmm.
But
I got to go back to one thing that you said here and that I've got just assimilated in the brain here. Are you saying that the bill, Josh Harkin's bill, SB 2753, was changed in the Senate committee with an amendment that neutered everything as far as public schools? Did you say that?
The original bill, as it passed, applied to state agencies, counties, municipalities,
All right.
Community colleges, everyone. That also had a provision in that time for punitive damages, compensatory damages, injunctive relief, and declaratory relief. So the argument that this is a trial lawyer bill, it was originally introduced with those types of damages. Then, as it went through the committee process in the Senate, they removed everything. They removed the trespass. They removed it from counties, municipalities. They sort of amended it over into just educational facilities, like colleges and universities, and that was it.
Was that what that's also what the other bill stated, was it not?
And
was
so,
for schools and educational facilities, schools and things such as that?
Well, as it passed the Senate, it did not have public schools in it. My conversations with the Senate...
Wait a minute, if it didn't have public schools in it, what did it have?
All it had was colleges and universities. And Paul, all of this is online. I brought copies to SuperTalk today to show everyone what the original bill, as introduced by Senator Harkins, how it passed out of committee, and then the conference report that was sent to me.
Then why would you hold this and not go through the conference process? Why would you hold this till the last minute with those disagreements?
Paul, I did not hold anything to the last minute for any disagreement. My position all along is the bill did not adequately address the women, children, and grandchildren in the state of Mississippi. It's important that you have a 6-year-old granddaughter that someone can't go into the bathroom and mess with her. It is important that if you have a 16-year-old daughter, that they don't have someone going into the bathroom with them.
I agree with you. Look, first of all, this was a Celeste Hurst bill that was killed. Representative Celeste Hurst. It was HB 1428, the SAFE Act, and it defines female, male, sex, all of those things, and related as far as Mississippi law is concerned. So it set the parameters of who we're talking about. It protected the privacy and ensured the safety of individuals in certain traditionally secured areas on public property, like single sex, changing facilities, restrooms, educational housing for exclusive use, either females or males. So why would you kill a bill that did all of that if it didn't put in there the Department of Mental Health?
Some bills make it out of committee. We had another avenue on the Senate. They had already passed that bill. We passed out the Women's Bill of Rights. I brought the SAFER Act up in Judd A, which was the Senate bill, which was identical to Representative
This was
Hurst.
Representative Dana McLean's bill?
Yes, sir.
Well, it says here it also died in conference.
Paul, I sent 2 signed conference reports. We have 2 signed conference reports, and I have the receipts of where I sent those over to the Senate. This is my signed conference report, if the viewers will look, that I sent over to Senator Wiggins, who refused to sign it.
All right, but let me, on this, I'm a little confused on this Dana McLean bill that she introduced, the Women's Bill of Rights in the House, and you took that up in Judd A. That just defined what a male was, what a female was, and what sex was. It did not prevent anybody coming into the restrooms, the locker rooms, or the dorms. Am I right or wrong about that?
Both of them.
No, first of all, am I right or wrong about that?
That did not address specifically with regard to bathrooms. What it did apply to is in code statutes that it defined male, female, woman, child, mother,
So
father.
you did let that one out of committee?
Yes, that did come out of committee.
But again, it did not stop anybody from going into the locker room and dressing a boy with dressing with a girl.
No, it did not. But
Okay.
I did, Paul, bring the Senate SAFE Act out of committee.
Well,
That
I understand that, but it did little. All it did was define things.
Well, we put
All right,
reverse.
we'll continue the conversation when we come back. Quick break. Back with more. With the chairman of Judd A, it's Joey Hood in the House of Representatives, District 35, Attala, Choctaw. Webster and Winston counties. Joey, we thank you for coming in. Here's one of the things that the C Spire text line and others are just asking, and I have the same question. Celeste Hurst had her bill, which really mirrored Josh Harkin's bill on 2753. Her bill, you killed it somewhere mid-February. It was one of the first ones that said, no, it's gone. Her bill mirrored, and by the way, it died in conference, but her bill mirrored Dana McLean's bill that you did let out of conference. The only difference between the two was Josh's bill and Celeste's bill both protected women in the bathroom, where Dana's bill, all it did was just define the difference between a man and a woman and sex. Now, if you were really concerned about protecting, certainly in those venues of education where most of the impropriety is taking place, wouldn't you go with that to have a win, some kind of a win, instead of just not take anything?
Bill, Paul, we took up the Senate Safer Act. We passed out the Bill of Rights. We had vehicles alive to keep these issues going, and it went all the way to conference. What I do want to focus on, Paul, is this. The House passed a rule suspension yesterday to bring back the Safer Act. It's my understanding that
that was after the fact.
Paul, let me finish, please.
Finish. What's the status of that?
And the Senate, it's my understanding, passed a rules suspension resolution to bring the Safer Act back. So now we're going to have before both chambers a bill to address the Safer Act. The House has the high position on this issue. We passed or sent a Safer Act over to the Senate that they refused to sign, that actually had damages in it if someone has them come in the bathroom on them or their spouse. The one that the Senate sent over did not define it. Actually, the first bill that came out included punitive damages. So I would argue that's more trial lawyer than what I inserted into the bill. All we want to do is have a bill that has some teeth in it, Paul. And the teeth is they can enforce that action. And that's what we want to do.
Why would you put the legalese in here? But listen, because everybody tells me that at 7:40 on Monday night, this past Monday night, 7:40, clock is ticking. You know, if you came in with nothing, it's still going to be difficult. But if you make major changes, how are you going to do that? The deadline is 20 minutes away. All of a sudden, after not hearing from you, you finally contact the Senate with 20 minutes, clock is ticking, and you say, look, this is a good deal, but I want you to put in there expanding lawsuits for plaintiffs' lawyers. And you put a lot of legalese in there. And then you knew the lieutenant governor was going to be opposed to that. Why would you do that in 20 minutes remaining?
Paul, let me explain. For the 2 weeks after a report was sent over, the chairman and I had discussions. I wanted to make a tougher cause of action, not a fluff bill. The bill that was sent over as it passed the Senate only included educational, took out counties, towns, agencies, and everything. I was adamant that we're going to include public schools. Okay? The conference report that was sent over, the chairman and I discussed all throughout the day about the cause of action and what I wanted to have inserted in that bill, and he was aware of it leading up to the 2 weeks prior to that. So whatever information you received that I waited to 20 minutes before the end of time is not accurate. And I've got the text to prove it, Paul.
So you're saying you're changing the consequences, the punishment, the penalties is what you wanted to change? There was no penalties in there at all?
The only thing that the Senate report sent over was said they could sue someone. All I included in there was treble damages and attorney's fees. So if you got awarded $500, you get $1,500. That's all it did. The original bill, as passed the Senate.
So you were willing to kill that bill for that?
I'm willing to do what it takes to get a good bill that has teeth in it that the people of the great state of Mississippi can go with. And that's the House position, and we are going to move forward with this bill, and we want to make sure that they have a right.
It could have already been taken care of. Now you have to have somebody come in and do some cleanup on this one and hope to keep it alive as far as the Safer Act is concerned.
I disagree, Paul. You're not privy to all the communications that we had, And
tell me what I'm missing here as far as if you had said, okay, they could still be sued. This would still be against the law. We still have some mechanism to address what's going on in Washington, D.C. Just had the U.S. Senator Cindy Hyde-Smith on talking about Title IX, and at least we would have had something akin to other states. Now, because you wanted to give trial lawyers the ability to sue 3 times as much, we got nothing.
Paul, I disagree. We currently have.
Well, you can disagree, but tell me where I'm wrong.
You are wrong. The original bill that was filed had punitive damage, compensatory damages, declaratory relief. It was removed by the Senate. The House position is that we want to have a bill that the taxpayer or anyone that's agreed can take and be taken whole with. And so that's what we did, Paul. And I disagree.
I don't understand that. When you say taken whole, if you're sued, well, that's subjective, is it not? Or what are we talking about making whole?
Paul?
It depends on the infraction of that particular case, individual case, does it not?
Do you agree that, I believe, and my position and the House position is we want to have a bill that is tough. We want a bill that has actions and consequences. We don't want something that does not have actions and consequences. Contrary to what you've been told, there was prior communications. I have that via text that we were working forward with this process. We sent signed conference reports over there, and that's currently where we are. We have a rule suspension in place, and I plan on bringing up a bill today or in the near future to address the SAFER Act for all people.
Are you the only one going to do this, or is there other mechanisms to do this?
The only mechanism, I'm not aware of what the Senate passed yesterday, but I do know the House passed a SAFER Act. We did name the bill the SAFER Act. We did not move off of that. We kept that name with it, unlike the Inspire Act.
Do you have to go? Does it have to go back through Judd A in that process?
It'll be
to your committee.
Yes, sir. It'll be referred back to our committee.
And if it is referred to your committee, at what point would you say, no, I'm going to let this die?
When this bill comes to the committee,
if it doesn't have what you asked for yesterday, would again die?
We're going to bring a bill up that addresses damages for someone that have them walk into the bathroom on them.
Well, the Senate bill had that. Lawsuits were authorized in the Senate version.
We are going to bring a bill out that has consequences for individuals that break this law.
And are the consequences in your demands? I'm trying to figure this out. We can save a lot of time when you guys gavel in this morning. Are the consequences that you want the same as you alluded to in the one that's died? Triple action, triple the amount.
Damages. I do plan on introducing treble damages, and I do plan on allowing attorney's fees.
And so that's basically the same thing that you required last time?
Yes.
Okay. So if that one dies, you'd be comfortable with it also?
No, I wouldn't be comfortable with it dying. I think we're going to work this bill through the process. Now that we have an open dialogue, I was communicating, contrary to what the questions that you're asking me that I was not communicating up to the last minute. We had communicated up into the weeks before that with regard to this.
I'm just getting information from colleagues and others who were there who said it was 7:40 on Monday night, 20 minutes before deadline, and still nobody saw you, and then you walked in and said, here, and this is what I want with that one, which is a major change, which you probably couldn't do in 3 days, and you want it done in 20 minutes.
No, I disagree. We had a signed conference report that was sent over to Chairman Wiggins earlier in the day, but Chairman Wiggins would not budge on it, and so we tried one last-ditch effort to try to save it. But here we are, Paul. We're going to move this bill forward.
I understand.
And we have a rule suspension, and we have a solution moving forward.
Did you mention to someone that nobody in the state really cares about this bill?
No, Paul. A lot of people care about this bill.
The Dana McLean bill that you did let out of committee, did it have triple damages?
No, it did not. It didn't even have a cause of action in it, Paul. It just defined the words and the terms of male, female, and everything else. Actually, the original bill that's introduced actually had all those definition terms in it. When it went to the Senate committee, it got removed, left like male and female there. And there's a lot of changes.
So you're basically saying the data bill just didn't do that much?
No, I'm not saying that. The Dana bill actually addresses the difference between boy, girl, mother, father, and also differentiates between high school athletic activities and such.
And that's why you let it out of committee?
And we wanted to keep 2 bills moving through the process.
I got you.
And
I'll give you final thoughts when we come back in just a moment.
Thank you.
and a school violates this, and there is a situation where a guy goes in, such as in Virginia, and molests a young girl, who is sued?
Paul,
is the school sued?
Paul, bottom line, and I'm going to say this right now. Bottom line, the Senate's version that passed out of the conference report they sent me has absolutely no teeth in it. And I'm going to stand strong because in the situation you're talking about, if the school or the college doesn't do anything, you cannot sue them. Okay, you cannot sue the school.
You can't sue the school.
No, you can't
There's
sue
no
the
civil damages or anything.
You cannot do that. The original version allowed them to do it. The Senate watered it down. Watered that bill down.
No, I'm
Paul,
talking
let me finish.
currently.
Paul, let me finish.
I'm going to give you your time.
Let me finish.
I just want this one question.
Paul, I want to finish.
Is the school culpable in any way on this?
Under the Senate's bill, the school is not
saying.
culpable.
I'm talking about now in law.
Under law, now, anyone can sue anyone for any reason. You know that,
And the
Paul.
school.
Yes, anyone can sue the school. But Paul, I understand you're going somewhere, but I'm going. The bottom line is we want a safer act that protects our children and our teenagers and our daughters.
Would that be to sue? Could you sue the school in your bill?
No. In our conference report, we did not put that in there. We kept identical language because to the Senate, we had some definition changes with regard to legislative intent and a couple, but it pretty much mirrored the same. All we want to do is to make sure they have a cause of action. Now, if the Senate, if Chairman Wiggins wants to bring a bill out, or Senator Harkins wants to bring a bill out, that allows them to sue the public schools, to sue the universities like the original intent of the bill, we'll definitely entertain that today.
So your bill was triple damages to the plaintiff and to the attorney. But
all it did is allow damages for the victim and allowed attorney's fees. That's it. The original bill had more relief and punitive damages in it. The narrative that someone is pushing that this is a trial lawyer bill is absolutely false. This is to protect victims.
But Joey, at the end of the day, the only differences between the reason that you let this die was because there wasn't enough money for the victim or the plaintiff or the attorney.
That's absolutely false, Paul. And I don't know who's telling you that.
You just told me that.
Paul, we're going to make sure we have some teeth in this bill. We sent a signed conference report over to that fact. If the Senate does not want to pass a bill that has any teeth, that's unfortunate. What we're going to try to do is pass a bill that we can all agree on and make it safer for our women, our children, and our grandchildren.
Your thoughts on... Yeah, go ahead.
In the narrative that I let something die or I didn't, this bill came all the way through the process to the end of the week. I was in communications for 2 weeks, contrary to what some people said. And so, but the bottom line, we're back in front with the SAFER Act. We have a rule suspension, and we're going to try to work this bill and make it safer for Mississippi.
Is the deadline on this one at sine die, or because of a rule suspension?
I'm hoping we can get a bill. I'm hoping as soon as we get the rule suspension clarified, and I don't know exactly what the Senate passed, so I'm not privy to that, but it's hopeful that we can get a bill together, get something worked out, and move forward.
He is Joey Hood, chairman of Jut A in the House. Any thoughts on the Medicaid situation going on, where your speaker has decided, all right, let's put this through a referendum?
Paul, one thing's for certain. Speaker White, I've known a long time. He's a colleague, he's a friend of mine, and I've been inspired by his leadership this year. Not only has he taken steps to change the MAEP formula to better all education for Mississippians, but he's taken an active lead in trying to provide health care for low-working Mississippians and hard-working Mississippians. He has kept bills working through this process. He has moved them along, and I'm proud of his leadership. And I don't know where we go from here. We will see today. I think he wants to let the people vote on it. Unfortunately, the Senate continues to kill the ballot initiative referendum. And so it would be a non-binding referendum is my understanding because the Senate continued to kill the other ballot initiatives. So that's where we stand.
You don't think the House has any part in an agreement with the ballot initiative? In other words, you're basically saying if the Senate would just acquiesce to the House, then we would have had it?
I don't think
but
so.
You could say that on just about everything, couldn't you?
I don't say that.
Like the SAFER Act.
I think they wanted a higher number of signatures. The House wanted a lower amount of signatures. And, we want to make it easy for individuals. Not easy, but we want to make it where the
And there are
citizens
a lot
have
of people out
access.
there who wanted to stay as hard as possible because of things like medical or recreational marijuana and a lot of other things. But that's another story for another time. So the way we have it now is that it will be brought back up. And if there are more, as you say, teeth in it, which means more money for trial lawyers and the victim, then you would probably put your stamp on it.
Paul, we're going to make sure that we have a bill that has some teeth in it.
Yes, sir.
That is going to make sure that makes our
Let me say
bathrooms
this
and
real
everything
quick.
else safer.
I salute you because 95% of the people over the many years I've been doing this would not sit in that hot seat. You decided to do that, and I thank you so very much. I appreciate it. And again, I salute you for that.
Hey, Paul, and I just want to thank you for letting me come in. I just want to close for just 1 second. And
you got 10 seconds.
thank you so much for the opportunity to serve. We're going to continue to try to provide a safer atmosphere for all of our women and children and continue to try to provide health care coverage for all hardworking Mississippians. Thank you.
You think the women are safer this morning because of that?
We're going to have a rule suspension. We got a solution moving forward, and
Thank you,
I look forward to seeing how